Good morning, everyone. Welcome to today's hearing. Today we're going to begin hearing from expert witnesses instructed by the inquiry. But it may help if I just say one thing before we start. We're not inviting the experts at this stage to give us their opinions on possible recommendations for changing the existing state of affairs. That's something that will come later on, but for that reason they will not be asked questions about potential recommendations at this stage, and we shall not be inviting core participants to provide us with questions in relation to that matter. Yes, Ms. Grange.
Yes, thank you, Mr. Chairman. If we could have our building control expert now, Ms. Beryl Menzies, please.
Ask you to read out the witness affirmation text.
I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Ms. Menzies. Would you like to sit down, please, and make yourself comfortable?
Thank you.
Yes, Ms. Grange.
Yes, thank you. Good morning, Ms. Menzies. Thank you very much for coming to give oral evidence today and for all the assistance you've provided the inquiry with its work. I'm going to be asking you questions today about your expert report, which was prepared for Module 1 of Phase 2 of this inquiry. If at any point you don't understand any of my questions, please ask me to repeat it or put the point in a different way. If you can try and keep your voice up, the lady sitting to your right is transcribing. We want a nice clear note of your evidence. Now, if I can just go to the reports that you've provided to the inquiry. You first provided us with a report in October 2019. That the reference for that is BMER 601. There's that report. And then there was also an appendix to that report containing plans, drawings and sections. That was BMER 602. And then we had an errata sheet containing corrections to that October 2019 report. Those corrections were April 2020, and that's BMER 603. Thank you. And then we have an amended version of your main October 2019 report. That was dated April 2020, and that incorporates the corrections. That's BMER 604. There we go. And that's the main report that I'm going to be asking you questions about today. And just to complete the picture in terms of all the written reports you've provided, there was an appendix to that amended report, again containing plans, drawings and sections, dated April 2020. That's BMER 605. And then there's been a further very short corrections sheet, an errata sheet, dealing with some very minor further corrections that you've done in the last few days. That's BMER 606.
Yes.
So that's the complete suite of reports we have from you. Can I just at this stage go to the last page of your report, your main report? That's BMER 604 at page 160. And we can see in the last paragraph there, we have a declaration there. And we have your signature. Is that your signature?
It is.
And have you provided this expert report in the same way that you would provide a report to a court?
Yes, I have.
And can you confirm that the factual matters set out in your report are true to the best of your knowledge and belief?
They are.
And does your report represent your true and complete professional opinion on the matters addressed within it?
It does.
Great, thank you. So I just want to start now with some questions about your qualifications and your background. If we turn within that main report, BMER 604, at page 3, we can see here that you've set out your professional qualifications and and your experience. And we can see that you are a Fellow of the Chartered Association of Building Engineers, the CABE. Can you help us? How long have you been a fellow of that organisation?
Since it became a chartered organisation, which was about 4 years ago. Prior to that, it was the Association of Building Engineers, which was preceded by the Incorporated Association of Architects and Surveyors.
Right, yeah, thank you. And you tell us also that you were president of the Association of Building Engineers between May 2009 and May 2010, is that correct?
Correct.
How long have you been a member of the Association of Building Engineers, approximately?
30 years?
Yeah, so a long time.
A long time.
Yeah. Now, just looking back at your career, is it right that your first role in the industry was with the Greater London Council in the Building Regulations Division between 1973 and 1985?
Yes.
And if we look at the bottom of this page, we can see there under that heading that you trained and promoted through grades within the division to become Group Officer responsible for the Fire Precautions Act and building legislation, and Deputy Senior Surveyor responsible for entertainment and sports licensing in Greater London. We see that there.
Yes, that's correct.
Now, can you help us? That first role, the Group Officer responsible for fire precautions, the Fire Precautions Act and building legislation, just help us. What did that role involve?
The building legislation would have been at the beginning the London Building Acts, dealing specifically with matters relating to means of escape and very large buildings where special provisions were made under Section 20 of the 39 London Building Acts Amendment Act. And the Fire Precautions Act was, we prepared fire certificates. The Fire Precautions Act preceded the regulatory reform fire safety order,
Yes.
as we know it now.
Yes, thank you. That's really helpful. And after that, you tell us that you moved to the London Borough of Tower Hamlets, and you tell us that you became a chief engineer implementing the building regulations and the London Building Act, with responsibility for specialist officers dealing with innovative new buildings under construction. So we have that there.
Correct. That was at the time of the Docklands redevelopment, so it was a very, very busy office.
Yes, yes. And then since 1991, you've been an independent fire consultant.
Yes.
Can you just, in short, explain what that involves?
It would be employed by clients, and they could be local authorities or generally independent clients, whereby they would be looking for advice in relation to achieving compliance, mainly with the building regulations as we know them now, or to conduct risk assessments under the order,
Yeah.
as they are required.
Under the Regulatory Reform Order 2005.
Correct.
Yes. And you are a director of Menzies Partners Limited. What does Menzies Partners Limited do?
Mostly fire consultancy and now some building surveying. My partner does that. I only do the fire surveying side.
Yes. Yeah. Now, just help us. To what extent do you think that the fact that you've not worked in a local building control department since 1990 affects your ability to comment on practice within local building control departments?
A good part of that independent practice has been working for local authorities and seeing how they individually practice.
Yes.
And I've also been on the receiving end of building control and subject to what they require and the information that they receive, etc.
So from that answer, do we take it that you feel you've got a good awareness of what a competent local authority building control department ought to be doing?
I do. My involvement also with SICAIR, the registration body for approved inspectors, means that we look at both sides of the coin, so to speak. So I get a good insight from way things are changing and how each side reacts to each other, in fact.
Yes. And just finally, in terms of your experience, can you also confirm that you've previously been a member of the Fire Safety Part B Committee of the Building Regulations Advisory Committee, or BRAC, B-R-A-C?
That's correct in relation to the revisions of Approved Document B in 2006.
Yes. Yes. And can you confirm that you've previously been a member of the Building Control Performance Standards Advisory Group, the BCP-SAG of BRAC?
Correct, and I think that still exists, but since the fire and the changes that have pursued following the Hackett report, we have not met.
I see. Yeah, thank you. Now, I want to turn now just to some general questions at the beginning about the regulatory regime. And if we look at, just pick it up at paragraph 55 of your reports, BMER 604, page 12, we can see there that you say the primary legislation was and remains the Building Act 1984. Section 91(2) of the Act states that it is the function of local authorities to enforce building regulations in their areas subject to Section 5(3) exempt bodies, 48(1) effective initial notice in force, and 53(2) effective initial notice ceasing to be in force. So there you tell us that the Building Act 1984 is the primary legislation. Does that mean that's the main source of obligations for the building control body, that they're derived from that Act?
Inasmuch as that instructs the local authority to enforce building regulations in their area and allows regulations to be made, building regulations to be made, and approved documents to be formulated under the government or designated body.
Yes, thank you. Now, as you say, and you've just touched on it there, we know that the building regulations themselves are made by the Secretary of State pursuant to a power given to them in the Building Act 1984, and specifically that's Section 1 of the Building Act 1984, isn't it?
Correct, yeah.
And we also know that Section 6 of the Building Act 1984 gives the Secretary of State the power to issue practical guidance to the building regulations, and those are the approved documents that you've just referred to, aren't they?
They are.
Thank you. Now, just on that topic of approved documents for a moment, they are not themselves the building regulations, are they?
No, they are not.
And is it fair to say that their purpose is to give practical guidance as to how to meet the requirements of the building regulations themselves?
It is, but they are not the only means of doing so. One can adopt British standards or other guidance or start from basic principles of fire engineering.
Yeah.
But they are used to set the level at which one should attain a minimum standard of reasonable fire safety. They are minimum standards for most generic buildings.
Yes.
But if you had an unusual building, you may not even go near approved document B, but you'd always look to the standard in them to compare.
Yes, as a benchmark.
Indeed, yes.
Yeah. And that description that you've just given, is that how they should be understood by building control bodies themselves?
Yes, I've got no reason to think they would think otherwise.
And does it follow that non-compliance with an approved document does not necessarily mean that there's been a breach of the building regulations?
Correct.
In your experience, what role do the approved documents play in the day-to-day work of a building control officer?
Primary document of reference, I would suggest. I don't know a building control officer who's not got an approved document B in particular that's not thumbed. Yes. And very well used and annotated.
Yes. And is it right that although the approved documents are not the only way to comply with the building regulations, is it fair to say that if they are to be used, they should be used holistically, i.e. read as a whole, rather than just dipping in and out and considering sections in isolation?
Correct. It's very important because each part, B1 to B5, relies on the other. So an assumption in B3 leads on to recommendations in B4, or something in B2 will be reliant on B1 and vice versa. So it has to be taken as a whole, no cherry picking as such.
Yes, I see. Yeah. Now, thinking about in the context of a building control officer's work, does it follow that it would be necessary to identify at an early stage on any project what route for compliance was being used, route for compliance in order to achieve the building regulations?
Being on what guidance would be adopted, yes.
Yes, so you're clear, are you, that a building control officer ought to have a good understanding at the outset of the project, whether it's using approved document B as the route to compliant or a fire engineered solution that's going to be separate from that?
Yes, and if the person looking at that project felt they did not have the experience, say, to deal with a fire engineering route, then they should speak to somebody and gain outside, perhaps, advice.
Yes. And if the approved documents are going to be used, would it be necessary for the building control inspector to use the approved documents as the basis for all of their checks from that point onwards?
For most projects, yes. As I say, the approved document addresses most types of building, but the building regulations are not there to stop innovation. So if there was anything there that in the approved document that wasn't suitable for use on that particular project, then they would look elsewhere or ask for what was being proposed to be justified and to include in that justification where that justification was coming from.
Yes. And when you say that they might look elsewhere, would that normally be to some other kind of industry guidance or British standard?
Yes, in my experience, it would normally be a British standard. Or if it's something that had occurred, say, relatively recently, because the approved documents amendments quite a performance to get that amended. So sometimes it would be an industry guidance document from a recognised industry body that would be referred to.
Yes, I see. Now, full plans applications. I want to ask you some questions about these for the moment. We've heard that the building control process at Grenfell Tower is described in the context of a full plans application. Is it right that any works that include a workplace and are subject to the Regulatory Reform Fire Safety Order 2005 require a full plans application to be made?
Yes, if the process that's adopted is the local authority building control route.
Yes, as
Yes.
opposed to the approved inspector route.
Correct.
Yes, I see. And if we can turn within your report at page 22 now, we can see that you've helpfully set out there for us. This is Regulation 14. Perhaps we ought to just pick it up on the page before, just to orientate ourselves. If we go to page 21, we can see at the bottom, this is Full Plans Regulation 14 of the Building Regulations 2010. And I want to focus on subsection 3 for a moment. So it says there, full plans shall consist of a description of the proposed building work, renovation or replacement of a thermal element, change to the building's energy status or material change of use, and the plans, particulars and statements required by paragraphs 1 and 2 of Regulation 13. And then I think we can pick it up then at C, any other plans which are necessary to show that the work would comply with these regulations. And little b is a specific requirement where paragraph H4 of Schedule 1 imposes a requirement relating to a drain or a sewer or
Correct.
disposal main, yes?
Yes.
Now, just looking at section 3A there, where it requires a description of the proposed building works, can you explain in practice the level of detail you would expect to be provided in that regard?
It will vary with each project, but if it was a new build, it would have to state it's a new build. If it was an extension, a refurbishment, renovation, the basic main topics, structural alterations, additional residential accommodation, things that would be matters that are addressed under the building regulations.
Yes, I see. And would you expect, I mean, what kind of level of detail would you expect? Would you expect drawings, plans to be submitted?
Yes, drawings, plans of a nature that would principally show that the means of escape and the fire brigade access were viable. Most things can be amended as the design progresses. It's very difficult to move the building if the fire brigade can't get there, so that has to be a fundamental proposal that the brigade's fire access is viable. And the means of escape is a prime factor, and if it requires additional staircases, etc., they would require major redesign. So the principle of escape is generally paramount to indicating that it is viable.
Yeah. Now, means of escape we know is B1 in Schedule 1 to the building regulations, and fire access is B5.
Correct.
Just help us, if though there were going to be renovations or refurbishments which affected the external wall and touched on B4, would you expect to see detailed plans relating to that, showing compliance with the building regulations?
If it was a major component of the project, yes.
Yeah.
Not necessarily at the initial stage, but it should be part of the description, and a description that would outline the extent of the actual external wall work.
Yeah. And we may come back to this later. Would it include the materials to be used in the external wall?
Experience would suggest at that stage it may not be defined what those materials are, because the ongoing planning discussions may be protracted. But the principles of it should be established in an early stage of the project, not necessarily at the actual point of submission, but as a prime aspect of it, early into the process.
I see, yeah. And then we see there section...
I'm sorry, can I just
Sorry, yes.
The purpose of a full plans application, as I currently understand it, is to provide information to building control that will enable building control to see that the work is going to comply with the building regulations.
Correct.
If you don't know what the materials proposed for use are, how can you tell whether they comply with the building regulations?
If you had a small project like a house, you could probably get all the information at the point of the building reg submission. The way the project develops, it's very unlikely that at the point of a full plans application, you would have all that information to hand. The reason being, you want the comfort as somebody doing the project of knowing that building control is on board and that you're getting some indication that they are happy with the project. But in the meantime, the design team is still furthering through and ploughing through all the various stages of the design to end up, it may be the client's changing their view, it may be that planning is dictating that you change your view. So you would not expect for a full plans application, other than the most simple of buildings, for all the details to be there. But you need to have sufficient details to know that it's viable. And the critical ones are those that will not require a major redevelopment of the design.
Well, I have to say, I just wonder whether that's what the regulations say, or whether the regulations actually contemplate that you should have all the information before you make a full plans application. I suppose ultimately that's a question of law, but...
Yeah, the reason... There are two forms of gaining building regulations approval. One is the building notice, and one is the full plans. The full plans is dictated to be necessary for a building where the Regulatory Reform Fire Safety Order, the order, imposes a requirement that the building basically should be fit for purpose and that the fire precautions are appropriate. To avoid a situation where a building is built, is then occupied, the fire risk assessment is carried out, and a significant amount of work is required by virtue of that assessment, the government decided that a full plans application should be made for any building where the order applied to that building on occupation, whereby the fire authority, who are responsible for compliance with the order, can look at the building and say, by virtue of that use, we don't think this is appropriate, and they recommend that the following measures are incorporated at the construction stage. It was found in previous years when the two pieces of legislation, when it was the Fire Precautions Act, were separate, that people were being asked to put in additional staircases because the details of the building known to building control at the time on occupation were different. So the legislation allowed additional measures to be required by virtue of the order, should we say, and the government was keen to avoid that because of what it imposed on the building owners and the developers, etc.
Yep.
All right, thank you.
Just going back then to Regulation 14.3a. So you've explained what you say is meant in a description of the proposed building work. And I think you're placing reliance there, aren't you, on the fact it talks about a description of the work, yes?
Yes, but then the plans go on to indicate compliance.
Yes. Because then we come, so my next question was about regulation, so 3C there, it then says any other plans which are necessary to show that the work would comply with these regulations. So is that what you're saying, as well as the description, you've got to have enough necessary to show that the work would comply with the regulations?
Yes. I think my description of how the full plans regime works is supported by the fact that the government allows, there is provision within the regulations to allow a conditional approval.
Yes.
Whereby the building regulatory body can impose conditions which then become requirements by law, whereby additional information is subsequently submitted for review, and that can be accepted or rejected at the time.
Yes. Yeah, great.
And that would be a condition of submitting further plans which demonstrate compliance, is that right?
Yes, plans, details, justifications for what's proposed, etc. If the plans show a contravention, that application must be rejected.
Yes. Yeah. Now, just picking up then on another section of your report about this topic, and I think in essence we've heard what you've said about this already. If we go to paragraph 233 of your report on page 60, and I just want to look at the first few lines there, you say, on anything other than a small project, all the details required to show full compliance with the building regulations will not be available at the point a full plans application is deposited. And then you say the initial details submitted should indicate that the means of escape proposal is generally compliant in principle and that the fire service accessed is or remains adequate. And then you say if the applicant and the building control body agree, a conditional approval can be issued. And then you go on and explain that. So that effectively is what you've just been explaining to us just now.
Yes.
Now, on its face, the phrase, and this picks up on the chairman's questioning, the phrase full plans does suggest that all plans relating to the works would be submitted to the building control body. But is it fair to say that, at least in practice, that is not normally what happens?
It is not the normal practice. I think if you look at the building notice route, you are required to accompany that with a site plan at a very large small scale rather, just to basically show where the building is and its relationship to other buildings. But by virtue of the building notice route, you don't actually have to give plans, details, etc. When you do the full plans, the term full, I would suggest, is not correct in practical terms. If you have a project, it may be that there are subcontractors who may not even have been appointed at the time the plans are deposited under the building regulations. So their details will be some way down the line. But the principles of compliance should be established early on, and then the details that follow on should then support that compliance.
Yeah. And after a full plans application is made, is it right that Section 16 of the Building Act 1984 requires the building control body to accept or reject the deposit of the application?
Correct.
And let's turn at this point to a flow chart that you've included in your report at page 58. Now, in this flow chart, you're setting out in detail how the building control process should work. And I want to focus for the moment on the box right in the middle of the page, the white box, the lower white box, right in that middle column, about what checks are done on receipt of the full plans application. So we can see the box before is that the applicant makes a full plans submission. They have to submit plans in duplicate plus additional copies and supporting details information as necessary to show compliance. And then you've got the next box is the checks that the building control body does at that point. And you've got that they check the fee is correct. Is there an applicant acting for the owner? Details of the owner included. Application is signed and dated. If conditional approval has been agreed, and if a 2-month extension period agreed. Now, would it be fair to add to that list that the building control body at that stage would be expected to check that sufficiently detailed plans were included within the application as necessary to show compliance with the building regulations?
Yes, if no plans were attached, then it would be rejected. Well, it wouldn't be accepted, correct. Yes, it would be a fair comment.
And if plans are attached, should there be at least some check at that early stage that those plans are sufficient in terms of establishing the principles, as you put it?
I believe your statement's correct. In practice, it may be an administrative check that there are plans attached to the application. There may not at that stage be a technical review of the application at all.
And when you say there might be an administrative check, does that mean that it might be administrative officers within the building control body that do those checks?
Correct.
And not necessarily the building control officers or surveyors that will be looking at the technical detail further down the line?
Correct, although I would add that that administrative officer may have been trained to look at what was coming in and to establish if it was considered reasonably acceptable.
I see.
Can I just ask this? Would I be right in understanding that when you get a full plans application, there are really only 2 ways, well, 3 ways forward. One is it's rejected, but let's put that on one side. The other 2 are that it contains, even at that early stage, enough information to demonstrate full compliance with the building regulations, in which case it gets passed, or some information is missing, in which case it can be the subject of a conditional approval, conditional upon subsequent deposition of plans which do show the missing information.
That's correct. The conditional approval has to be agreed by both parties. If the building control body looks at the application and thinks this is just not viable, we're going to end up with 1,000 conditions, then I would suggest they are obliged to reject it.
Yes, but what I had in mind was your answer to an earlier question that you don't necessarily, in fact, usually I think, expect all the information to be present about products and so on at the early stage of a full plans deposit.
Yes.
It suggests to me that if that information is not present, albeit for good reasons, it ought to be the subject of a condition, and that the condition ought to require the deposit of plans which do show the relevant products. Is that right?
That is correct. But some applicants do not agree to a conditional approval.
Well, in that case, they get rejected, I see.
Exactly.
Oh, well, that's how it works.
Yes.
Yes. All right. Thank you.
Yes,
Yes,
thank
Ms.
you.
Grange.
Now, at paragraph 240 of your report on page 60, you explain that after the building control body has undertaken its own evaluation of the plans, it then undertakes a formal statutory consultation with the fire authority.
Yes.
Now, we're going to come back to this topic in more detail later, but I just at this stage want you to describe briefly what that process, that consultation process with the fire authority involves.
Once the building control body is generally satisfied with the application, then they would consult the fire brigade. In London, there is a specified form which has been agreed between the fire authority and the building control bodies in London to use this particular form because it gives the information the brigade needs. I'm afraid at one point, some authorities were using the fire brigade basically as their means of escape, B1 and B5 consultants, which is not the role of the fire service. They are really just there to give a view of whether the measures are appropriate for the building in use, or perhaps to comment on any other particular fire-related matter. And that can be from a small shop selling highly combustible materials and subject to other regulations, or it could be fuel storage plants whereby they would obviously have lots of other comments as regards fire safety. But then the building regulations body would pick out those matters that the fire brigade comment on in relation to the building regulations and advise the applicant of the other comments the fire brigade had made.
Yeah.
But the application should not go to the fire service unless the building control body is satisfied that in general principles and subject to any conditions, they are satisfied with the proposals.
Yeah. So does it follow from that there would have needed to have been some form of technical appraisal of the application before it goes off to consultation?
Yes, definitely.
Now, we know, and you've already drawn the distinction between the full plans and the alternative to that. We know that the alternative is a building notice application. I just want to look at something you say about that on page 160 of your report, paragraph 571. Now, this is in the context of your discussion of the gas riser works at the tower, which we will cover in module 3, but I just want to focus on the general point that you make here. And you say in that paragraph that a building notice is an application that allows works to be carried out without the submission of full plans. It is usually adopted for small works and where statutory consultation with the fire authority is not required. And by some building control bodies where, albeit a building is subject to the order, I think there you mean the 2005 order, yeah?
Yes.
The works have a limited impact on fire safety. So is it right that this building notice route requires a much less detailed submission to the building control body?
Yes.
And can you just explain briefly, going back to full plans, what is the purpose of the requirement for a more detailed submission, for the full plan submission in the context of a project where the 2005 order applies?
It's to avoid works being required once the building is occupied. It should be the building is safe upon occupation, provided that the use as described at the full plans remains the same upon occupation.
Yeah.
I suppose you could give an example whereby, say, a warehouse is in fact submitted for building regs application and it's going to be used for the storage of steel. Now, it has been that a building control body would have accepted the basis of that application and may have perhaps accepted less fire protection than would be normal for a warehouse of that type on the basis it was only going to be used for non-combustible materials to be stored. But during the life of the building, that building becomes used for the storage of highly combustible or just general storage, whereby additional measures would be appropriate upon the change of the use of the building. That's when the order comes in, because the risk assessment must be appropriate and review the type of use of the building in relation to the fire safety measures.
Yeah.
These days, it'd be unusual for a building control body, in my experience, to accept the use of a warehouse for one purpose only, knowing that the building regulations and the fire safety measures relate to the building and during the time of its life, effectively. So they should be appropriate for a warehouse.
Yeah, I understand. Now, can we look at page 86 of your report now, paragraph 273? And you say there, building control invoiced Ryden for the fee. This was paid by cheque attached to a letter dated the 1st of September 2014. Building control by letter dated the 5th of August 2014 acknowledged receipt of the full plans application. This acknowledgement of the full plans application, in my opinion, was the date from which the statutory time limit for a decision began. You see that there. And just help us, what's the statutory time limit?
The building control body is obliged to respond to the application within 5 weeks, but if the applicant is agreeable and the building control body is agreeable, that time limit can be extended to 8 weeks, 2 months. For a larger project, it would be better if the agreement for the 2 months was agreed to allow the consultation to take place and the detailed review to take place on the decision.
Yeah. Now, you ultimately conclude in your report at paragraph 326 on page 100, if we just look at that briefly. We can see you say observations were sought outside the statutory time limit in the first sentence. The first details of the work received on the 24th of September 2014. It was not possible to have issued a decision within the statutory time limit. In my opinion, this supports my view that the full plan submission should have been rejected. You see that there?
Correct.
So that's your conclusion?
Yes.
Now, Mr. Hoban's evidence, when he gave evidence, was that he accepted that with hindsight, he should have rejected the full plans application due to a lack of supporting documentation. But at the time, he said he was, quotes, trying to work with them. And I just want to ask you about this. But before I do, I also want to ask you about something that Mr. John Allen, he was the RBKC Building Control Manager, what he said in his his witness statement. If we can look at that, this is RBK 3033930 at page 3, and I want to look at paragraph 14. And he says, Mr. Allen says, and I want to pick it up at the second sentence at the end of that first line, in recent years, with design and build, project information often arrived in stages throughout the build. Statutory time limits regarding approval or conditional approval or rejection were not usually adhered to in practice. And then in theory, if no decision was made, the application would be, quote, deemed approved, but in reality, no applicant ever took this point. So that's the evidence we have of the building control officers. And I want to ask you a series of questions about that. In your experience, is it common for building control officers to disregard the statutory time limit in that way?
I've never encountered that before.
You
Never.
haven't. Now, Mr. Allen refers, as we can see there, to the design and build model playing a role in that regard. So he's implying that because it's design and build, the information comes piecemeal throughout the build. Is that your experience, that on design and build projects, those statutory time limits are routinely not complied with?
No, not at all. It makes no difference whether it's traditional project progress or design and build. There is a point where the full plans application is made and the statutory time limits kick in. They are statutory.
Yeah.
From Mr. Hoban's comments, trying to work with them, yes, every building control body tries to work with their applicants. And I suppose the kindest thing you could do would be to ring them up and say, this is, I'm going to have to reject this. Would you like to withdraw it?
Yes.
But it wasn't done as far as I could make out.
Yeah. But you don't think that trying to work with them should ever mean that you accept an application within the time limit, which in fact doesn't have the right information attached to it?
it doesn't mean that at all. You should. It's a statutory obligation.
Yeah. Now, Mr. Allen also said in his oral evidence for the transcript, this is day 47, page 169 at line 7, he said for larger projects, the time just doesn't fit. The information just isn't available. Now, you've worked on a lot of larger projects over the course of your career. Do you agree with that?
No, I don't. The point at which the full applications would be made will be a point in the design progress whereby a building in concept has reached the point where it's known what it's going forward as. The finer details as to perhaps the finishes, the colours. Sometimes you can start a project and suddenly the client will want 3 extra stories on top. But there will be a point at which you could go to the building regs application and say, I am going to build a building on this site and I am going to do it with design and build, but here is the general principle of what we're going forward on. By the time you get to design and build, my understanding is the concept of that building in design is there.
Yeah.
So you would go forward on that basis. If you were going to build a building perhaps out of non-traditional construction, and by that I mean something like a hay building or something like that, then the discussions would have taken so far ahead of the actual application that the designer would have a good idea of what would be acceptable. And that would go for any big project or any small project that was unusual.
Yeah. Now, in terms of the consequences of rejecting a full plans application, if a building control body decides to reject that full plans application, is it right that this doesn't prevent building work from taking place?
That's correct.
What are the consequences if someone continues to build once their full plans application has been rejected?
Provided that the work complies with the building regulations, then there is no consequence. The building control body, if that building work starts, would generally inspect. They're not obliged to inspect, but as a contravention can only occur on site, then that was how the contravention would be found, and notices could be served on the person who's carried out the work that's in contravention to put that work right.
Yeah.
And if you have your full plans rejected, you can still submit information to the building control body for review.
Yeah.
And receive comments accordingly.
Yeah. So given all of that, what could be the benefit of passing a full plans application that was incomplete?
None really, but because it doesn't give any confidence to the applicant that going forward that they are not going to perform contraventions.
Yeah.
And presumably, if your application were rejected on the grounds that it didn't contain enough information, you could make another one.
Indeed, yes.
With more information.
Yes, yes.
Yeah. Now, just getting the framework of how it works, the full plans application comes at the beginning of the process. I now want to ask you just a little bit about what comes at the end, and that's the completion certificate, yes? And if we can look on page 62 of your report at paragraph 252, you tell us there, when building control is satisfied that the controllable completed works, either works within the scope of the building regulations, are compliant, the necessary third-party certificates have been received, and the required fire safety information has been provided to the owner, they must issue a completion certificate within 8 weeks of being notified of completion of the works. Now, is it fair to say, in the light of that part of your evidence, that the issuing of a completion certificate by the building control body is its confirmation that it is satisfied that all of the works comply with the building regulations?
Yes, the completion certificate, as you may have seen, says it shows evidence but not complete evidence of compliance, because the building control body officer is not standing there to look at every single aspect of the work.
Yes. And that's the theme of my next question. So in terms of the purpose of a completion certificate and its significance, to what extent is a completion certificate a certification that the works do in fact comply with the building regulations?
As far as could be ascertained by the building control body, yes. It is what everybody is aiming for, a completion certificate.
Yeah. But should we draw a distinction between the building control body being satisfied and the works actually complying?
By virtue of the regulations requiring the completion certificate to have that evidentiary clause within it, which says that as far as can be ascertained but shall not be taken as evidence of full compliance, to paraphrase it,
Yeah.
it can only be taken that far.
Yeah. Now, leaving the specifics of Grenfell to one side for the moment, can you explain generally how it might come about that a completion certificate could be issued where works did not in fact comply with the building regulations?
Only in as much as the inspections did not reveal the non-compliance, but subsequently something happened that did reveal the non-compliance.
Yeah. So maybe part of a building's removed and it shows that there's a deficiency in the building which the building control officer didn't see. Would that be an example?
Yeah, an extreme example would be a partial collapse of a building, something like that.
Yeah.
Or unfortunately a fire anywhere.
Now, I don't think we need to turn it up, but Dr. Lane says in her report that there are no provisions in the building regulations that give powers to the local authority to prevent the occupation of a building before the issue of a completion certificate or at any other time during building work.
Correct. But I'm sure the local authority, if they were particularly concerned, would contact the fire service, who could put a prohibition notice on the building or part of the building under the order.
Yes.
Or if they felt they couldn't for any reason, because the order, they couldn't use the order to that effect, then past experience under different legislation, injunctions have been sought for to prevent the occupation of a building that was considered unsafe.
Right. Yeah, I see. Yeah. But it's right, in principle, that the absence of a completion certificate doesn't prevent occupation of the building.
Correct.
Now, given that a completion certificate does not necessarily mean that the works are in fact compliant and doesn't prevent occupation, can you help us as to what the purpose of a completion certificate is for?
It finishes the process and it affirms by the building control body as far as they have been able to ascertain that the works do comply.
Yeah. Now, just a few questions now about this distinction between local authority building control and approved inspectors. As we know, your experience shows that you've sat on both sides of the fence or seen it from both perspectives. Does that make sense?
Yeah, I'm also a board member of the registration body of SICARE.
Yeah, of approved inspectors.
Yeah.
Yes, exactly. So I want to just get you to help us to understand the differences between approved inspectors and local authority building control bodies. Now, first, is it right that local authority building control bodies were required, certainly at the time of the Grenfell project, to be cost neutral?
That would be dictated by the authority, but that was the intent, yes. Generally, yes.
And did that apply to all local authority building control bodies?
I couldn't say that was applicable to all. Experience shows to me that some authorities used the money from building control for other purposes. It wasn't ring-fenced, and others, I believe, ran at a loss at times.
Right.
But the aim would have been, just in good basic economics, to be cost neutral.
Yeah.
It was a service for safety, yes.
Yeah. How did that work in practice? How would a building control body try and achieve that cost neutrality?
It would be by setting appropriate fees to cover their costs.
Yeah, I see. And those fees would be adjusted, would they, if they felt that their costs were increasing at a particular time?
I believe that they could have done that, yes, yes.
In your experience, did that present challenges for local authority
It was perceived that it did. Whether it did in fact, I don't know. The commercial challenges of attaining the work for a local authority were compounded by the ability of the approved inspector to set their own costs to cover work if that approved inspector's route was adopted.
Was there any standardisation of fees amongst local authorities, or did they just set their own as they thought fit?
At one time, there was a standardisation of fees. I cannot honestly say at the time of Grenfell whether that was in place.
Yeah.
Yeah.
Let's have a look now on page 45 of your report, paragraph 171. And you tell us there that there were two forms of building control body that could have been employed, the local authority or an improved inspector. Then, as now, both bodies carry out the same functions, except that the procedure is different. For example, a full plans application is not required if an approved inspector is employed, but the fire service must be consulted. An approved inspector has no powers of enforcement. If a contravention of the building regulations occurs, the regulatory role must revert to the local authority for enforcement action to be pursued. So you're helpfully telling us what the differences are in procedural terms there. So is it right that in contrast to local authority building control bodies, approved inspectors operate in the private sector?
Operate in the private sector, they can undertake work, basically deal with building control, with the building regulations on any particular building, but they are private individuals, yes.
Yeah. Are they operated, in your experience, so as to make a profit?
Yes.
Is it fair to say that on every project, the client will have an option whether to approach an improved inspector or the local authority to act in relation to a project?
They are required by virtue of their registration, which requires them to adhere to a code of conduct, that they cannot take on work if they have an interest in the actual project. So, for instance, they cannot do any design aspect, or they cannot, in fact, even be married to somebody who has an interest in the actual project.
Yeah. Now, you say that they carry out the same functions, but the process is different. Can you help us? How is it different in the context of a full plans application?
An application to an approved inspector requires the approved inspector to serve on the local authority an initial notice, which is either accepted or rejected by the local authority, and there are rules set down as to why they can reject and why they can't reject.
Yeah.
Assuming that application, the initial notice is accepted by the local authority, then as soon as possible after the initial notice is accepted, the protocol is that they would contact the fire authority as soon as possible after, having reviewed the project. They must consult the fire authority if it's subject to the RRO.
That's approved inspectors must do that?
Yes, they must do that.
Yeah.
They have to consult the fire authority if they are going to issue a plan certificate. You can ask an approved inspector to give you a plan certificate whereby they have looked at the plans and are saying, yes, it complies with the building regulations, subject to conditions, perhaps.
Yeah.
Before the approved inspector issues their final certificate, in other words, the completion certificate, they again have to consult the fire authority.
Yeah, I see. So they have to consult at the beginning and at the end?
Yes.
Yeah.
If you're going to put up a building to which the RRO will apply on completion, you have to go to the local authority, don't you? Or do you? That's my question.
No, because the process...
I was just looking back at Regulation 12, which seemed to suggest, 12.2, that you have to deposit full plans with the local authority.
I think they may have been amended by the approved inspectors regulation.
Oh, is that the case? Right.
It all gets very confusing, to be quite
As
honest.
you can tell.
Yes.
Even after all my years, I still get very confused.
Yeah.
Right. Well, we can.
We can check that point. Yeah. Can we look now at on page 45 of your report, paragraph 172? Sorry, it's the next paragraph. Apologies. And there you tell us a local authority building control body was not and is not required to employ professionally qualified staff or to be a member of any officially recognised body such as Local Authority Building Control, LABC, nor is it required to adhere to the guidance issued by bodies such as the LABC or the Building Control Alliance, the BCA, or to submit the annual statistical returns requested by the Building Control Performance Standards Group, the BCSPAG. So you've explained to us there a number of things that the local authority building control body was not and is not required to do. Is that situation different with an approved inspector?
Yes, the approved inspector's registration is conditional upon compliance with the SICAIR, Construction Industries Council's regulatory body for approved inspectors, to comply with its code of conduct,
Yeah.
which includes compliance with the BCPSAG, the Building Standards Group performance standard,
Yeah.
and failure to comply with that or to adhere to, or they are encouraged to adhere to protocols issued by such bodies as the Building Control Alliance, whereby issues arise because of factors changing over the years, where the Building Control Alliance, a recognised body, which is a combination of approved inspectors and local authority, will in fact make recommendations of a way a certain process is dealt with, or in fact they will actually give out technical guidance, as we know from dealing with Grenfell.
Yeah. So I think you've agreed that they are subject to the CICAIR, the Construction Industry Council Approved Inspectors Register Code of Conduct,
Yes.
and accompanying guidance notes.
Yes.
Now, under that code of conduct, is it right that approved inspectors must have, quotes, robust systems in place to ensure appropriate standards of technical competency and consistency is achieved across their organisation?
Yes. I would point out, though, at the time of the Grenfell full plans application, the code of conduct is not the code of conduct that exists now.
Yeah.
However, the aspect of robust systems was in the previous one and is in the current one.
Yeah. So under whichever regime, old or new, they've got to have robust systems in place.
Correct.
To ensure appropriate standards and technical competency.
Correct.
And is it right that they are obliged to submit annual statistical returns required by the Building Control Performance Standards Advisory Group, and that's a subcommittee of the Building Regulations Advisory Committee?
Correct.
And are those statistical returns designed to allow government and the approved inspectors to monitor the service they provide?
Yes.
Now, we know that local authority building control officers are subject to the Building Control Performance Standards. Often that's shortened to BCP, is that correct?
Yeah.
And they are promulgated by that Building Control Performance Standards Advisory Group. That's right, isn't it?
Correct.
Do those same performance standards apply to approved inspectors as well?
Yes, in fact, the local authority building control is not obliged to adhere to the building control performance standards. By virtue of their registration, the approved inspectors are.
I see. Okay. So in terms of the status of those building control performance standards, those BCPs, are they guidance or do they have a more special significance?
They are guidance, they are good practice, they are to benefit the progress of an application through the process of building regulations. They are to be hopefully fair to both sides, the applicant and the building control body. An approved inspector, by virtue of his registration, is obliged to adhere to them, adopt them. Whereas currently, a local authority building control body is not obliged to.
I see. Now, can we look at what you say at paragraph 178 of your report on page 46? Now, I'm going to pick it up in the 6th line down, where you say the standards and supporting guidance set out the expected minimum level of performance of a building control body in discharging its duties and responsibilities. Can you see that sentence?
I can, yes.
Yeah. Now, in your experience, did building control bodies at the time generally understand that those performance standards were the minimum standard?
I believe so.
And were they, in fact, routinely adopted and complied with by local authority building control bodies at the time of the Grenfell refurbishment?
I believe they were. The biggest objection by anybody to the BCPSAG is the return that had to be done periodically, because of if they didn't have the processes in hand, it was quite a major project to provide those statistics.
Right, yeah. In your view, so we've looked at the differences between the two regimes. In your view, are approved inspectors subject to a more stringent performance regime than local authority building control officers?
Yes, approved inspectors are audited every 5 years or in the first year of their registration to ensure that they are adhering to the requirements of their registration, and have to reapply every 5 years for re-registration.
Yeah. Now, apart from the fact that it's mandatory for approved inspectors to submit compliance data returns, whereas it's not mandatory for local authority building control departments to do that, is it right that the codes and guidance that govern the two regimes are not materially dissimilar?
Correct.
At the time of the Grenfell project, was there any requirement for local authority building control officers to carry out ongoing continuing professional development, or CPD?
It would have been, and still is, a requirement of their professional qualification if they had it. And I would have thought and would have expected ongoing CPD to be a part of the regime of the building control body for their officers to keep up with changes as they came about.
Yeah. So you would expect a competent building control body to be providing for some continuing professional development for their officers?
I would have expected, although I have seen, if I may refer to the job descriptions of the various officers within Kensington and Chelsea.
Yes.
At one level, they were responsible for their own CPD.
Yes.
So whether they intentionally put that back to the officers or not, I couldn't say from what I've seen to date.
Was that common practice to do that?
No, it would normally be because heads of local authorities were informed from government of changes in legislation and changes in the approved documents. That information would have come through the local authority and should, and it didn't always, end up on the desk of the building control manager, the head of building control, and that information would then need to have been disseminated to all the staff.
Yeah.
So without doing a form of CPD or some form of training, I don't know how that would have been done.
Yeah.
Even if it was only an A4 sheet giving information.
Does it follow that you don't think it would have been good practice to have just let building control officers sort out their own CPD?
Correct.
And what about approved inspectors? Was there any requirement at the time of the Grenfell project for approved inspectors to be carrying out ongoing CPD?
Yes. Yes, it's a part that, as I say, part of their qualification as a professional qualification, and also because a level of professionally qualified persons would be required to be running an approved inspector's office.
Yeah. Is CPD within the building control and approved inspector industry often provided by manufacturers in your experience?
Yes, it is.
Do you agree that this may result in a lack of objectivity in the training that's provided and as such is undesirable?
Yes, often it's the only available because of the cost of providing CPD and undertaking CPD. But often it is. One would hope that internally those with experience would be saying to junior members, beware, this man is trying to sell this product. And if they'd heard anything within that presentation that was not quite as it should be from a building control body point of view, to have point that out.
Yes.
To raise it, flag it up, really.
Yeah. Now, can we have a look at Mr. John Allen's witness statement again? RBK 3033930 at page 2, and I want to look at paragraph 11. And he makes the point there. He says, however, we were competing with the private market in building control, and to try and ensure that RBKC internal projects selected in our building control department, I would meet once a month with the corporate property team to talk about jobs past, present and future. Do you see that there?
Yes.
So in practice, are local authority building control services in competition for projects with private sector approved inspectors?
Yes.
To what extent do you feel that privatisation of the market led to a reduction in the quality of the work carried out by building control bodies?
In my experience, I can't say that I've ever seen a lessening of quality.
Right.
I would hope not, because most approved inspectors are trained by local authority or were building control officers in local authorities.
Yeah. Now, just a few questions about interaction with other departments. If we can turn to CLG 10006814 at page 11. Now, these are the building control performance standards from 2014. And this is standard 3, which is consultation. That's a heading, consultation. And we can see the standard there is in the green box. And it says, building control bodies shall undertake all statutory consultations in a timely manner, and the observations of consultees should be communicated in writing to clients. It shall also consider the benefit of undertaking additional consultation. It shall, where appropriate, cooperate in an integrated approach to consents relevant to development control. So we can see that's the performance standard from 2014 about consultation. So it talks there in the first line about undertaking statutory consultations in a timely manner. Can you just help us? What would those statutory consultations be? Would it be, for example, with the fire authority?
It'd be the fire authority in relation to Part B, but it would be sewage undertakers, etc., for other aspects of the building control process. In a timely manner refers to the time limit that an approved inspector has in relation to issuing certain documents, and building control body having the time limit to issue its decision as regards the deposited plans within the 5-week time limit or the agreed 8-week time limit. Effectively, I think this is saying, if you have a building control application that you need to consult elsewhere with, don't leave it till 3 days before your mandatory time limit is up, yes, because it's impractical, it's unreasonable to expect a response.
Yeah. And then we can see in the second sentence, in that third line down, it said, it shall also consider the benefit of undertaking additional consultation. Can you help us? What might that additional consultation involve?
It would be if, as the conditional information perhaps was coming into building control, or there was an alteration to the project whereby something fire-related changed and would have particular resonance with perhaps the fire authority. It may be that the owner has suddenly found out that the land on which fire appliances would approach, the right to pass over that land has been withdrawn, or that the person who owns the land has put up a massive fence or something. So the best person to talk to about fire brigade provisions is the fire brigade, so you would go back to them.
Yeah, I see. Is it normal in your experience for additional consultation to take place?
It's not unusual. There has been a problem in the past with delays on consultations with certain fire authorities simply because they are overburdened with work in all sorts of aspects.
Yeah. And then finally, we can see in that last sentence, it says, it shall, where appropriate, cooperate in an integrated approach to consents relevant to development control. Now, would it be fair to say that this section envisages coordination between different local authority bodies that are responsible for giving consents in relation to any given development?
That would be the aim. Unfortunately, it doesn't always work. The two that are always spoken about are planning and building control.
Yeah.
Some authorities, those departments, well, generally the building control department is within the planning development department, but not always. But generally, in my experience, there's very little integration of the departments.
Right.
There was a time in days of austerity, proposal for building control bodies to actually check planning requirements, but I don't think that went very far in my experience anyway.
Right.
But I do know of some planning authorities, if they have an unusual planning application, will talk to building control to see if it's even viable, or perhaps they'd like to see something in that planning application that's unusual, and would it be viable under a building regs application.
In practice, what sort of interaction would you expect to see between the building control department and the planning department in a local authority?
Minimal, or generally none.
Right. But what would be good practice if good practice were being followed? I mean, it says here you've got to cooperate in an integrated approach to consents.
A good... well, I do know some authorities have sort of monthly meetings between the various department sections, and it would be perhaps for a planner, say, to flag up in front of the building control head this rather large development or the unusual development that's coming ahead, to say, would you care to give an opinion on it?
Yeah. Would that ever include information sharing? And if so, what kind of information would you expect the two to share?
I can't think where that information has been shared. It's, to be quite blunt, post the fire, Grenfell, it has occurred. Pre the fire, very rare, unless it was an unusual development.
Yeah. You tell us, this is paragraph 262 of your report on page 67, that there's no indication in this case that there was any interaction between RBKC Building Control and the RBKC Planning Department. Would you have expected to have seen any interaction in terms of
At that time, no.
No. Are you critical of this lack of interaction?
The planning aspect is different to the building regulations aspect. Building regulations are not concerned with the colour, the landscaping outside, etc., and the impact generally on the area. The building control aspect is the technical aspect of the actual building.
Mr Chairman, I think that's a very good moment for our morning break.
Yes. All right. Thank you very much. Well, Ms Menzies, we're going to have a break now. We have a break morning and afternoon. So we'll take it now. We'll resume at 20 to 12, please. And I think I'd better say the same to you as I've said to all the other witnesses. Please don't talk about your evidence to anyone while you're out of the room.
I won't.
Thank you very much. All right. Would you like to give the usher?
Thank you.
Right. Thank you. 20 to 12, please.
Thanks.
Would you ask Ms Menzies to come back in, please? Thank you. All right, Mrs Menzies, ready to carry on?
I am, thank
Good.
you.
Thank you. Yes, Ms Grange?
Yes, Ms Menzies, thank you. Just to pick up on a couple of points from this morning's evidence, we were talking just before the break about the potential for interaction between a building control department and a planning department, and you've explained that certainly wasn't your experience, certainly pre-fire. But can you give us any good examples of where you've been aware of interaction occurring between a planning department and a building control department?
To be quite honest, no. And subsequent to the fire,
Yeah.
if they've had tower blocks, I am aware certainly of one local authority who was putting tall blocks in front of building control at the planning stage. But apart from that,
Okay.
other than, say, a large shopping mall or something like that, there would be some interaction.
Okay. And then on the cost neutrality point, were you aware that there was a requirement on local authorities, a national requirement, to be cost neutral?
I knew there was at some stage. I am not sure if that's current. I'd have to defer that to others.
Can I just take you to a document on this? It says RBK 30590036. This is a DCLG circular dated the 25th of February 2010 to local authorities about the Building Local Authority Charges Regulations 2010. And if we go on to page 10 and look at paragraph 33, we can see there it says, under the 2010 regulations, local authorities are required to set their charges with the aim of achieving the overriding objective of ensuring that, and then it effectively describes being cost neutral. Do you see that there?
I do, yes.
Yeah. And we can see that's from 25th of February 2010.
Yeah.
Now, some questions now about the role of building control and their function. If we can turn within your report, BMER 604, page 12, and look at paragraph 52 now. And you say there, it is important to recognise that the role of a building control body is only to check for compliance with the requirements of the Building Act and the building regulations. A building control body has no role in the design. It checks submitted proposals and inspects works on site to ascertain compliance. So is it fair to say that what you're doing there is drawing a distinction between assessing designs that have been produced by others and having input into the design itself?
Yes. There's always been this question of when a building control body enters into discussion pre-application with a design team, by virtue of saying, no, that won't comply, but if you do this, X, Y, and Z, it will comply, is that design? I don't think it is, because you're not producing anything to say there's a design that I prefer or anything as such.
Yeah.
But the analogy with an approved inspector is that they cannot have any other role on a project at all, and a building control body should not be involved in that project other than to check. It's not their role at all.
Yeah. Now I'd like to look at Mr. John Allen.
Sorry, just to clarify, it sounds from that as if you take the view that good practice would prevent the building control body from giving advice about what would or wouldn't comply.
To be quite frank, it makes life easier for everybody if that advice is given and that that guidance is sought. And at one time, it was actively encouraged by all the bodies concerned on the regulatory side, in as much it was even termed to become part of the design team. But you have to be very careful that you are not designing, because that's subject to all sorts of other rules and regulations.
Yeah.
And it's not your role. You can't check your own homework.
Yes. Now, picking up on exactly that point, I want to take you to something that Mr. John Allen said in his evidence. If we can go to day 47, page 90, and pick it up at line 18. And just picking up at the second half of Miss Grogan's question there, at line 20, she says, do you agree that a building control body has no role in design? And he says this, not necessarily, because there was not design, because it's for the people to obviously design the project, but many years ago it was very much about that doesn't comply, reject it, it's not good enough. And then we can go on. And then he says, but very much now, it's more about being part of. It's about being part of the team as well. And it may be looking at options and suggestions. Now, pausing there, would you agree that the role of a building control body has changed so that now the building control body is part of the team described by Mr. Allen?
I don't think it's new that it would be part of the team, but you are not part of the team in as much as you sit down at the design team meetings and contribute design options. They are put to you, and you might say, that door needs to be there. But apart from that, it would be a case of, I don't particularly think that complies. You need to justify that.
Yeah.
And you can talk about the justification that they present to you, but it's certainly you're not doing any design. The implications of it being a building control body doing design and bringing in the CDM regs and the consequences, because it could come back to you and say, you suggested this, and the consequences of it were not as desired, shall we say. But no, you're not paid to be a designer. You're not paid to do that.
Yeah. Let's just look a little bit more about what Mr. Allen says, because this will, I think, draw out some of the distinctions you're making. He says, if we look at line 3, the end of line 3 at the top there, he says, so typically plans might be marked up with suggestions for them to take forward. You're not designing it because you definitely can't design, but you would try and be slightly more helpful than that. Rather than just say it doesn't comply, just give perhaps some guidance to them to help them comply. It's not a rejection culture, you know. You're trying to help people build in accordance with the building regulations, I hasten to add. Now, you see that there. Now, just taking some of the examples he's referring to there, to what extent do you agree with him that a building control officer could mark up drawings with suggestions for them to take forward, but still avoid encroaching into a design role?
I don't know, apart from this particular body, that actually marks up any drawings. You might sit and point at a drawing at a meeting, or you might try and illustrate by a very rough sketch, and a very poor sketch it would have been in my case, as to what you were trying to explain to them. But I would never, and I know of no other body that says, if you do it like this, I've drawn it out for you, it'll be okay. I don't know of any other body that does that.
So does that mean what you saw on the Grenfell project in terms of building control officers sometimes marking up designs, that was completely outside your experience previously?
It was, and to be quite honest, it looked like what was done at Middlesex House, which was the old building regulation division of the GLC, in relation to the Fire Precautions Act.
I see.
We would issue drawings that were marked up in separate colours, etc.
I see, yeah. Do you agree with his concern about any rejection culture?
It's not the aim to reject plans unless they show a non-compliance, and the aim is to end up with a building that has a reasonable and adequate level of safety. Nobody goes out just to reject things willy-nilly, shall we say. They have to have good cause to reject. But there are statutory obligations and statutory time limits within which you have to work.
Yeah. Now, I want also to take...
Right, can I just ask this? The question whether someone is designing or not might the answer to that question might depend on the purpose for which it's asked, but is it your evidence that building control bodies or building control surveyors don't understand themselves generally to be involved in design? Is that
Correct.
right?
They are told not to.
Yeah.
Yeah.
And they don't think they're doing it.
I've never heard one say, oh, I'm part of the design team, I do this as part of the design.
Yeah.
You are there to check somebody else's work, not to add your
Yeah.
design in.
Yeah.
Thank you.
We're going to come on in a minute to look at what you've said about Mr. Hanson in your report, because you've said in your report that you think he wrongly took it upon himself to effectively redesign parts of the fire strategy in terms of smoke control. I'm going to take you to that in just a moment. But before I do, I just want to look at some of the evidence that was given about the role of building control by starting with some of the Ryden witnesses. If we can look at day 23, page 77, line 2. This is Mr. Simon Lawrence's evidence. He was the contracts manager for Ryden, and he was being asked about how he saw the building control role. And if we pick it up at line 2, he's asked the question, was it your understanding that building control was there basically as your complete safety net? And then he says this, not as a complete safety net, because we've got a design team that should be designing in accordance with the regulations and compliance, but building control is there to ensure that we do that, and they check the plans that we do. Now, in your opinion, to what extent is it fair to describe building control as any kind of safety net?
The only safety net I would suggest it would be for the general public, in as much as it also effectively is a third level review. But as building control is not there at every single stage of the construction, it cannot be seen as a complete safety net at all.
Right. And to be fair, that Mr. Lawrence doesn't say it's a complete safety net.
No, that's true.
But he's saying that they're there to ensure that we do that, and they check the plans that we do that. Would you agree with that?
If they have plans to check, yes.
And if we look at what he said when pressed a little bit further on this issue, if we look at page 114, line 20, actually, let's pick it up at 15. There's the question posed. So you might expect them to pick up any non-compliances, but is it really right, Mr. Lawrence, to say that Ryden were relying on them as if they were part of the subcontractor chain, providing you with a service? And then Mr. Lawrence says this, well, they were providing us with a service. Do you see that there?
Yes.
And then he goes on, and then he's asked by Mr. Miller, is that how you saw it at the time? Yes, because we were paying for them to check compliance against the building regs and then check the works that was installed. Do you see that there? Now, in your opinion, to what extent is it fair to describe building control as providing a service in the context of, say, a design and build contract like this?
It is a service, it's a building control service, but it is only to check as a safeguard against what is being proposed. It is a service and they are being paid, but it's not the same as being part of a design team with the profit-making aspect and the need to satisfy the client. I would always say they were standing off from the design team, overviewing what was put to them, and they have no other role in that design team. But it's fair to say they were paying for a service, yes.
Yeah. Now, finally, in the context of Mr. Lawrence's evidence, if we can go back and look at page 74 and pick it up at line...
Sorry to keep butting in, but you made in answer to an earlier question, you said that they were the third line of protection for the public. And one might ask the question, although they're providing a service, to whom are they providing a service? Is it the public or the contractor?
They are providing a service in the context of whoever I would suggest is making the submission for the full plans application, but their role is to ensure there is a minimum level of safety for anybody who is in or about that building, and that will be the public or the occupants or whoever.
Thank you.
Yeah, thank you. Now, if we can look at page 74 now of Mr. Lawrence's evidence, and this was in the context of appointing Exova. He was asked why it wasn't important to him to put in place a fire safety strategy, even if only for the lower 4 floors, to ensure that the resource was reliably there on a clear basis for Studio E to use or for you to use. We can see that question at the top of that page. And we can see his answer at line 8. So he says, we thought we had a resource with building control.
Yes.
And then the question, building control isn't a resource, is it? Not in the sense that you contract it in. Well, we pay for their service to check the compliance and provide advice regarding the regulations. So we can see that there. In your view, to what extent can a contractor reasonably rely on building control to fill the role that might otherwise be filled by, say, a specialist fire consultant?
They can't, because the input from the fire consultant would be much higher than the building control and may influence the design to the point where it could be taken as design, although most fire engineers would say they are not subject to the CDM, but depends on the role they're contracted with.
Right.
But I don't think they should put a reliance on it. It's certainly not the role of a building control body to act as the fire consultant on a project.
Yeah. And can I look on this theme at something said in Mr. Soons's witness statement now? This is SEA 14273 at page 43, and I want to look at paragraph 91. And I want to pick it up, just look at the last 4 lines of that paragraph at the top of that page. He says, although we had Exova to advise on some such points, my understanding was that the ultimate decision as to whether something complied with the Building Regulations 2010 was with building control. Do you see that there?
Correct, yes.
And the same question, I mean, to what extent can an architect reasonably rely on building control to fill the role that might otherwise be filled by a specialist fire consultant?
It can't. I don't believe it can. Building control is checking a proposal that should be complying with the building regulations.
Yeah.
It's not a case of an architect or anybody puts forward proposals and then expects building control to say it's wrong, but if you do this, it'll be okay. That's not the role.
Yeah. Do you think that it was a known phenomenon in the building industry back in 2012 to 2016, the time of the Grenfell project, that there was a lack of clarity about the proper role of building control? Do you think that in the industry, some people had an inaccurate expectation of what building control were doing on projects?
Not in the period you've described. Earlier, much earlier than that, I would have said there was.
Yeah.
And in non-urban situation, perhaps even more so. But certainly in London, I think by that time, following several fires, the role was quite clear.
And that was clearly understood by, say, design and build contractors?
I would have thought so, yes.
Now, I said we'd look at it. I want to look now at what you've said about building control's response to the proposed smoke ventilation system solution. If we go and look at page 89 of your report, and I want to pick up at what you say at paragraphs 289 and 290. Now, just to be clear, the smoke ventilation system is going to be the subject of in-depth analysis at Module 3 of the inquiry. So we're not going to discuss it in detail here, but I'd like to ask you about those paragraphs in terms of what it's saying about your view of the building control function in this case. So you say at 289, the annotation on the plans is detailed and extensive. That's the annotation by building control, isn't it? By Mr. Hanson.
Yes.
This response is far more than I would have expected from a building control body. In my opinion, the extent of the non-compliant issues was significant in a number, and the application should have been rejected. Alternatively, the applicant should have been encouraged to withdraw the application and resubmit following a review of the proposals by their fire safety consultant. And then you go on in the next paragraph. In my opinion, Paul Hanson wrongly took it upon himself to effectively redesign the fire strategy. This is not specifically precluded in legislation for local authority building control, but the role of a building control body is to check for compliance. It is possible that such annotation could have been considered as design under the CDM regulations, which was not the role of the building control body. It is noteworthy that approved inspector regulations prohibit their involvement in design work in which they have a role as a building control body. Now, could you just help us as to what it was about that example that led you to conclude that Mr. Hanson had gone beyond the proper role of a building control inspector or officer?
He stated in his comments that the proposals were unacceptable, and then he marked up drawings with notes and lines of annotation which said, if you do it like this, it'll be okay.
Right. And in your view, that goes too far, does it? That oversteps the line in terms of the proper function of building control?
Yes, for the extent it was done, definitely.
And I think we may have covered this, but just for clarity, in your experience, is that common in the industry or is that rare?
Rare. I've never seen it before.
And at the end of paragraph 290, we can see that you've said it's noteworthy that the approved inspector regulations prohibit their involvement in design work. So do we take it from that there is no equivalent prohibition on local authority building control inspectors?
Correct. Just to say that the improved inspectors regulations prohibit it for all but such as a loft conversion or a small extension on a house, something like that, minor works.
And can you help us as to the rationale behind that distinction? Do you know why it is that for approved inspectors they are expressly prohibited from being involved in design, whereas we don't see the same with local authorities?
It is likely that, it's not likely, it does exist where an approved inspector is within a larger organisation that provides other construction regimes such as design, thermal, efficiency, etc. So it's to make that distinction within an entity. You have this role as a building inspector, an approved inspector, and that is totally independent of any other. And again, it's marking your own homework, but it's probably also a result of history and learning from lessons as it's gone along, and the legislation perhaps for local authority has never kept up with that for the approved inspector.
Yes, I see. Thank you. Now, in terms of standards to be inspected of building control officers and approved inspectors, can we just return to paragraph 172 of your report on page 45, which we looked at earlier? So we can see you say there that the local authority building control body was not and is not required to employ professionally qualified staff or be a member of any officially recognised body, such as the LABC, nor is it required to adhere to the guidance issued by bodies such as LABC or the Building Control Alliance, the BCA, or submit statistical returns. Is it also right that officers who work for the local authority building control bodies are not required to be members of a professional body?
Correct. They are not required. It may be stipulated in the job descriptions because it is thought that they should have, and such as the LABC, the local authority building control overseeing group body, shall we say, I believe it's now in their code of conduct, but I can't actually state that it is in their code of conduct currently.
Yeah. And when you say, nor is it required to adhere to the guidance issued by bodies such as the LABC or the BCA, what do you mean by that? Do you mean that there's no obligation for them to even be aware of that guidance?
Correct.
Or is that correct?
Correct, yeah.
Right. So I'm now going to ask you some questions about the standards to be expected of a building control officer. And when I ask these questions, I'd like you to answer by reference to the standards of a reasonably competent building control officer. Now, in terms of the building regulations and the guidance in approved document B, would you expect a building control officer to be able to deal with any issues under B4 that come up on a building project without specialist assistance?
In respect of B4,
Yes.
no.
Can you explain why you say that?
The construction of the walls may be new to that person. They may not be familiar with it. It may be incorporating materials that are new to the market, or a combination of materials that have not been used before. And as regards the space separation aspect, it's quite complicated to understand until it's explained. And with existing buildings, it can be not daunting, but it can be, again, as I say, complicated when you get into the you get into the realms of a notional boundary becoming a relevant boundary relative to space separation and the like.
I see. And if a building control officer came across those new issues, as you've described it, with an external wall, what kind of specialist assistance would you expect them to be seeking?
I would expect them to go up their line management. The senior officers may have that experience, and if it goes right the way through and that experience is not available within the department, it may be, in the case of a London borough, they would go to the London District Surveyors Association, which all the members of the association are the Greater London area, to see if they have any experience. If not, they should, in my opinion, look outside to a specialist body such as the Building Research Establishment or one of the larger fire engineering practices for comment.
So I think what you're saying is there are plenty of avenues that you can go to for specialist assistance and support if you identify that that is required.
Yes.
Now, notwithstanding whether a building control officer was required to adhere to industry guidance, what general awareness would you expect a building control officer to have of guidance documents produced by, for example, bodies like the LABC or the Building Control Alliance, the BCA?
I would expect them to have an awareness. LABC documents, by virtue of usually the head of department going to their meetings and then disseminating the information he's gathered, by virtue of being on, let's say, the LABC mailing list. It may not have gone right down to the most junior member, but it certainly, I would have thought, would have gone to the senior members who would then disseminate. And being made of the Building Control Alliance, where their documents are available online. Yeah. So once being told there is information out there, people would know where to look.
Yeah. Now, in terms of familiarity with industry guidance, you've covered some of the available industry guidance in your report. And I'm going to highlight some passages within that and ask you some questions about it. So BR 135, we know, is expressly referred to in paragraph 12.5 of approved document B. And you say in your report at paragraph 310 on page 97 that both John Hoban and Paul Hanson should have been familiar with BR 135. Is that right?
By virtue of it being in the approved document, yes.
Yeah. Mr. Hoban's evidence was that he was aware of it having been referred to in the approved document, but had never read it. For the transcript, that's day 45, page 53, lines 1 to 13. Would you expect a reasonably competent building control officer to have read BR 135?
If they had not had a job that involved it, I can imagine that some would not have read it.
But if they get a job, which is an overcladding project, which squarely requires them to consider B4, in those circumstances, would you have expected them to have read it?
Yes, unless they had been told it was compliant by another means. But as we know, there was no information.
Yeah, and read it in full. They should have read all of that guidance.
Yes.
Would you expect officers to have received training on what BR 135 says and how to apply it?
In honesty, I don't think could expect that they'd all had training. I would have expected if they weren't familiar with it, they would speak to a senior officer who hopefully would have that experience, or refer again up the line. But once you read it, it's not that difficult, but it's very easy for me to say it's not that difficult because I'm trained in fire safety.
Yes.
But a general building control officer may find it difficult, particularly as regards the classification of materials, as regards non-combustible, Class O, etc. They do get confused. And so if they've not been trained in it, not had it explained to them, it is easy for them to get confused.
Yes. So does that follow then that you would expect any building control officer who was dealing with those issues to have had some specific training in it? Or if not, to at least recognise he hadn't had that training and escalate it?
Yes. Training can be self-instigated, and there's a lot of information available, a lot of BRE documents that assist in these matters.
Yeah. Now, even if a building control officer hadn't read BR 135, would you expect them to be aware of the substance of various warnings that it gives about external fire spread and the use of certain materials in cladding systems?
If they'd not read it, probably not, but the approved document indicates what those walls should be of. And the terminology is reflected in both documents.
Yeah. So I think what you're saying is they should have picked up at least an awareness of the issues from just approved document B itself.
Yes.
Yeah. We know that there are various specific warnings within BR 135. For example, there's a warning about metal panels. Metal panels may melt and fall off and generate molten debris. Is that a general matter that you would have expected building control officers to have been aware of at the time of the Grenfell project?
Yes, in as much they should be aware of certain metals have a low melting point.
Yeah. So aluminium.
Yep, aluminium.
And what about, there's a very specific warning in the third edition of BR 135 from 2013 about the proliferation of new and innovative materials and increased volumes of combustible material being used in external cladding applications. Would you have expected building control officers to have been generally aware of that proliferation of new materials?
Generally aware, it's hard to say, but by virtue of dealing with materials in all aspects of building, they should have been aware of those that were highly combustible, yes.
And what about being aware that products that have a good surface spread of flame may still have the potential to create falling debris and indeed themselves contribute to the overall fire load?
They should know about that. But as I say, there seems to be an ongoing confusion as to what Class O, specifically, as people would have been more familiar with, meant or means in terms of external walls. Some people believe that Class O means it's non-combustible, which it certainly doesn't.
No.
No.
Would you have expected a competent building control officer at the time to be aware that Class 0 doesn't mean non-combustible?
Yes, I would.
Now, BCA, the Building Control Alliance Technical Guidance Note 18, is another piece of industry guidance that's referred to in your report, and you refer to both issue 0 and issue 1. One was dated, I think, July 14 and one July 15, maybe June, in your report. Would you expect a reasonably competent building control officer to have been familiar with the contents of that guidance, that BCA guidance?
The familiarity with BCA documents, I feel, would come via their management structure and whether that management structure, by virtue of its LABC connections, would have disseminated the information through.
So would a reasonably competent building control department have made sure that those pieces of guidance were properly disseminated down to building control officers?
Yes, I certainly believe they should have, yes.
Would you have expected building control officers to have had their attention drawn to it when it was first issued in 2014 and again when updated in 2015?
Yes.
And would you have expected them to have received any training on what that technical guidance note says and how to apply it?
Experience would suggest it would not have happened in all building control departments for reasons of lack of time, lack of money, all sorts of reasons. But unfortunately, I don't think that would be the case, no.
So you don't think they would be aware? Would a reasonably competent building control department have provided some training on how to apply that guidance?
I can't say that I would expect all building control bodies to have provided that training, because such materials and such developments do not occur throughout the country. But one where, such as London, one would have hoped it would have been the case.
But would you have expected building control officers to have been aware that there was specialist guidance, for example, on external wall applications, and to have known that they ought to have escalated the matter were they to face a B4 issue?
Yes, yes.
Now, if we can turn to Mr. Hyatt's report at this point, this is PHYR 604. And I want to look first at what he says at page 124. There, paragraph 4.4.77, he says, as with the CWCT, I note that the Building Control Alliance issues regular bulletins and papers on construction-related issues. It also produces practical guidance for designers. And then he says, amongst which was BCA Technical Guidance Note 18, which, although its title suggests otherwise, deals expressly with approved document B2, paragraph 12.7, in terms of all the elements of the cladding system, including insulation. And then the June 2015 version, and he goes on about what that says. And then if we look over the page at 4.4.79, he's explained in the previous paragraph that he wouldn't have expected an architect, a specialist cladding contractor, or a rain screen contractor to be aware of those advices and circulars. But he says, I would certainly expect a building control department, either through direct membership of the BCA or indirectly through their membership of the LABC, to be properly informed of such advice. Now, is that consistent with your opinion?
I would agree with regarding the building control department.
Yeah. I'm not asking you about the other, because that's outside your area of expertise.
Yeah.
But then he says this at 4.4.79. He says, I also take the view that if a building control department or officer within such a department becomes responsible for such a cladding system on a project, in circumstances where previous experience is lacking, then that person should make full use of the information available at the BCA so as to be able to, in a properly informed manner, discharge its statutory duties effectively. Now, do you agree with that statement there?
Yes.
Yes.
Yes, I do.
Thank you. Now, you've also referred to the CWCT guidance in your report. This is at paragraphs 144 to 146 for the transcript on page 40. And you've said that in your experience, these documents have not been used by a building control body in relation to compliance with Part B of the building regulations. That's right, isn't it?
In my experience.
Now, we know that some of the available CWCT guidance was referred to in the NBS specification for this project as part of the employer's requirements. Although, to note, the oral evidence we've heard from Mr. Hoban was that he didn't recall having seen the NBS specification. Now, as to that, on a project such as the Grenfell project, Is the NBS specification, which is effectively the employer's requirements for how the building is to be built and the materials to be used, is that something you would expect a building control officer to be provided with?
No, the employer's requirements are information for the design team to produce something that fits those requirements but also fits the building regulations.
Yeah. Now, we know, though, that the drawings produced, say, by Studio E on the Grenfell project do cross-refer to paragraphs in the NBS specification. If I can just look at an example of that, if we can bring up the offline version of SEA 402499. And for these purposes, let's just look at the proposed section typical bay in the top right-hand section of this drawing. If we can blow that up as much as possible, great. And then go to the, thank you. So here we can see, these are some of the Studio E drawings, some of which we know were provided to building control, and they have little labels on them leading out to bubbles on the side, where we see, for example, P10, or we see H92 or L10. Mm-hmm. Now, would you reasonably expect a building control officer to follow that up and ask about what that meant if, for example, something wasn't clear on the drawing about the materials to be used?
Yes, would expect to inquire what it meant if there was not adequate written explanation.
So if, for example, there was a bubble and it said thermal insulation and it said H92 clause 776, and it didn't tell you what type of insulation was going to be used, would you expect a building control officer to notice that and say, tell me, what's the insulation you're using for this project?
Yes, and if I was referred to the MBS, I would say, no, thank you, you tell me what it says.
Yeah. So we know the MBS is a long document. You wouldn't even expect us to ever see any extracts from it. You would just expect to be told what was in it, yes?
I mean, I wouldn't object to receiving an extract from it if it gave me the information I required.
Yeah.
I mean, you can go and look up the MBS, but the actual contracted conditions may vary that NBS standard.
Yeah. But I think what you're saying is you would expect a building control officer to look carefully at these drawings to satisfy himself, for example, that he knew exactly what materials were being used in that external wall construction and around the windows.
Yes.
Yeah. Now, just carrying on with this theme of industry guidance, Mr. Allen's evidence was that the building regulations and approved document B are enough for the purpose of a building control surveyor, and they don't need, as a general rule, to go looking at industry guidance documents. He said that at day 47, page 40, lines 4 to 13. Now, do you agree with that?
No, the approved document gives the substance of what's required by the building regulations for normal, we'll call them normal type buildings. It doesn't address innovation, and it's not the role of a building control body to refuse everything just because it's not covered by approved document B.
Yeah.
So, yes, I would expect them to go look elsewhere or to ask for justification on what that justification was based.
Yeah. Would you expect a reasonably competent building control officer to be aware of previous fires involving external cladding facades on high-rise residential buildings?
Yes.
So, for example, we've got Knowsley Heights in 1991.
Yes, it would initially it would come probably via press, TV, etc.
Yeah.
And to be quite honest, the first thing they probably thought was, I hope it's not one of mine, because that's just the normal reaction.
Yeah.
But they would expect it to be. If it didn't resonate or currently on the jobs they were doing, it should perhaps have flagged up something in the future. But unless it was something particularly relevant to what they were doing, they may be aware of it, but not specific details, perhaps.
Yeah. Would you expect that there ought to have been some method of communicating within a building control department if there'd been significant previous fires?
I would like to think there would be, but again, it's going to depend on who's running the department and the various line managers, I'm afraid.
Would you have expected reasonably competent building control officers to be aware of international cladding fires, such as the spate of fires in the UAE in 2012, 2013, and then more later in 2015?
Yes, inasmuch as they were shown in the press, in the TV, and also they were focused on in professional journals.
Would you have expected the occurrence of such fires to have prompted any awareness on the part of a building control officer about the dangers of ACM?
Yes.
Within your industry, the building control industry, was there any discussion about these fires and the lessons that could be learned from them at the time of the Grenfell project, so between 2012 and 2016?
There were, I believe there was a letter from the fire brigade, certainly in London, that was issued, highlighting the issues, particularly after Lacanal House, etc. And it was prominent in the industry, in the professional journals. It would have been discussed, I would imagine, at the likes of LABC meetings, etc.
Yeah. Would you have expected a building control officer working in London to have been aware of the fire at Lacanal House?
Definitely.
And in particular that the fire involved the facade and the exterior of that building, as well as other issues?
At the time, my recollection is that the emphasis was on the loss of compartmentation,
Yeah.
not specifically on the external spread.
Right. When did you become aware that external spread was an issue following Lacanal House?
It was almost, I was reading the reports, particularly from Sir Ken Knight, which was produced before the coroner's report, I believe.
Yeah. During their oral evidence, Mr. Hoban and Mr. Allen were asked about conferences put on by the LABC, and particularly one conference which took place after the Lacanal House fire. Was the Lacanal House fire discussed within your industry at the time?
Yes.
And was there any general discussion or awareness of lessons to be learned from the Lacanal House fire amongst local authority building control officers?
I think, as I recall, what it flagged up was when works were undertaken without the proper measures being taken, the correct routes being followed as regards building control and the like, and the fact that within, say, the same organisation, works could take place without the correct checking, etc.
Yeah. Did the fact of that Lacanal House fire prompt local authority building control officers to begin to exercise particular scrutiny in respect of any works where there was the potential for facades to contribute to external flame spread in high-rise buildings?
Not that I can quote. I don't think it was particularly as regards the facade. It was more the loss of compartmentation.
Right.
That was my experience.
And do you think with high-rise buildings and knowledge about the dangers of loss of compartmentation, was there a sea change within the industry in terms of the level of scrutiny given to any plans that might involve a loss of compartmentation?
I think there was. I couldn't quote specific examples, but I think there was heightened awareness of the potential to lose compartmentation, yes.
Yeah. So I now want to ask you some questions about the skills you would expect a building control officer to have with regard to interpreting manufacturers' product information. If we can turn at this point to Mr. Jose Anon's witness statement, he's another RBKC building control officer. If we go to RBK 3029897 at page 7. And if we look at paragraph 34 at the bottom of the page, so just picking up what he says there in the first few lines, he says, as surveyors, we make the assumption that products used on a project and factored into the design have already been tested to the necessary regulations and standards. We cannot be expected to ascertain how safe a product is during a site visit. And then he goes on to say there are a range of accrediting bodies to ensure product meet with the relevant regulations and British standards, and the main bodies are the BBA and the BRE. Do you see that there?
Yes.
Now, do you agree with what he says there, that as surveyors you make an assumption that products used on a project have already been tested and that they cannot be expected to ascertain how safe a product is during a site visit? Do you agree with that?
I do not agree with the assumption aspect. If you see something on site that you don't know the details of, then you would query it. You would never make an assumption that products used are compliant.
Yeah.
You just wouldn't make that assumption.
And why not? Why wouldn't you make that assumption?
Because you don't know it's been tested just by looking at it, and you don't know what caveats were attached, if any, to that particular testing regime. There probably is a lack of knowledge about testing in relation to fire within the building control industry, but that has improved greatly over the years. But there are also, anecdotally, people talk, and it is known that product information is not always fully explanatory of everything that is caveated in a fire test.
Yeah. Now, you say that the lack of knowledge about testing has greatly increased over the years. So I think you said the situation's got better over the years,
Yes.
with a greater awareness and understanding of the need to scrutinise test information. Is that right?
Correct, yes.
And where would you put the Grenfell period in terms of that trajectory? So 2012 to 2016, what would you say the state was of awareness of the need to check testing information carefully?
I think there was an awareness at that time.
Yeah.
Yes, I do think there was an awareness.
Yeah, and you would have expected a reasonably competent building control officer to have had that awareness, would you, at the time?
Yes.
Yeah. Now, we heard from Mr. John Allen. He said that interpreting certificates such as the BBA certificate and product literature is a core function of a building control officer. That's what he said. That's at day 47, page 79, lines 25 to 18. Do you agree with that?
Yes.
Now, in contrast, we heard from Mr. Hoban that he was never trained to interpret certificates and that it was a very specialist subject that a fire engineer would understand. But as a building control officer, he wouldn't have had that knowledge. For the transcript, that this is at day 46, page 77, lines 14 to 22. Now, what skills and expertise would you expect a building control officer to have when it came to reviewing and interpreting product literature or certificates such as BBA certificates or LABC registered details?
BBA certificates, I find Mr. Hoban's statement strange in as much as BBA certificates are not the sole aspect of fire safety. Sorry, BBA certificates cover more than fire safety. So they cover structure, sound, all sorts of things. So I would have thought, have been familiar with all the different aspects. And it says, when read fully, that there are caveats and reliance was placed on tests.
Yeah.
I would hope that that would influence you to go and say, well, what did that test say? Because sometimes the manufacturer can even put limits on the test criteria when it goes to the laboratory. But until you read that test certificate, you don't know that, or you don't know that this particular element was tested between two concrete linings as opposed to aluminium and timber,
Yeah.
whatever. So I would have expected they would have interrogated the certificate.
Yeah. And does it follow from that answer that a reasonably competent building control officer would read those certificates in full, including any caveats?
A reasonably, yes, competent one, yes.
Yeah. Would you have expected them to have undergone specific training to help them with how to interpret such certification?
Experience suggests no. It's usually the training would be if you were trained on the job, so to speak, with somebody who knew that way forward.
Would it have been good practice to have had training to help assist building control officers with how to interpret such manufacturers' literature or testing information?
It would have been good practice, yes.
Yeah. But is your evidence that it wouldn't have fallen below reasonable standards not to have had that training at the time?
Experience suggests it didn't occur, yes.
I see. Now, you've said in your report, if we look at paragraph 440 on page 135, there we go. And you say this, you say, I'm aware that there was a BBA certificate in respect of the Rainabond ACM cladding. I have seen no evidence that this was provided to the building control body. In my experience, I would not normally accept a BBA certificate as sole evidence of compliance because they are usually heavily caveated and it is difficult to identify the limitations of the certificate without seeing the underlying test data. So I think that chimes with exactly what you were just explaining to us about your approach to test data.
Yes.
If not provided with the BBA certificate or a BBA certificate or something like it, what should a reasonably competent building control officer be asking for to satisfy themselves that a product used complied with the building regulations?
A test certificate of that particular construction or an assessment by an accredited body or some other competent person who would take that test certificate and give an assessment as to what they would think would be the outcome if that particular composition was involved in a fire.
Yeah. Would LABC registered details also be a source of information about building control compliance?
Yes.
Mr. Hoban stated in his oral evidence that a BBA certificate was something that we accepted as a standard. And when asked whether these were accepted without question, he said yes. Now, is that representative of what was happening more widely in the local authority building control industry?
I can only say probably yes.
But just to be clear, you don't accept that that was competent practice?
My experience of BBA certificates is such, yes. I would not take them as the only underlying justification.
Yeah. And just to be clear, sorry, I should have said that for the transcript, that evidence of Mr. Hoban was at day 46, page 15, lines 20 to 25. Now, Mr. Hoban said in his oral evidence that he did look at the BBA certificate for the Rainabond ACM panels. That's day 45, page 32, lines 15 to 21. Now, you didn't have that evidence at the time you wrote your report. And his oral evidence was, if I can summarise it, he said he would not read the certificate in detail, but would pick out the points that concerned him. That's day 46, page 16, lines 1 to 4. With regard to the Rainabond BBA certificate, he said he couldn't recall, but he maybe just looked at the first page. That's day 46, page 18, lines 15 to 18. Now, just to be clear, it will be a matter for the chairman and the panel to decide whether that evidence is accepted, that oral evidence. But can we just assume for the moment, let's assume for the moment that a building control officer did choose to look at a BBA certificate. Would you expect that building control officer to read more than just the first page of the BBA certificate?
Definitely. The front page just gives a summary. It's usually section 7 or 8 that relates to fire, and that gives any caveats that relate to the use or the reason the BBA certificate says what it says.
Yeah. Mr. Hoban's oral evidence was also that he would treat LABC registered details certificates as an acceptable standard. That was day 46, page 77, lines 14 to 22. Would your evidence apply equally to an LABC registered details certificate, i.e. you would read the whole of that?
Yes.
Rather than just any summary or box of that?
Read it in its entirety. Yeah.
Yeah. Mr. Hoban also said in oral evidence that he did not know what a BS 8414 test was. Now, would you expect a reasonably competent building control officer to have known about what a BS 8414 test was at the time of the Grenfell project?
By virtue of it being referenced in the approved document, I would have thought yes.
Yes, it's in paragraph 12.5 of approved document B, isn't it?
Yeah. They may not have known exactly what it entailed, but they would know of it, and by virtue of that, I would hope they would look further if they needed to on a particular job.
Yeah. Now, you say I wouldn't necessarily expect them to know exactly what it entailed. I want to test this a bit further. Precisely what level of understanding would you expect them to have? For example, would you expect them to understand that that was a system test and that only the exact system could be used if it satisfied the BR 135 criteria? Would you expect them to have had that knowledge?
Experience suggests they would not have, but having before them a job that would potentially involve that, and if it was presented to them, I would expect them to then delve into it to establish exactly 8414 Part 1 and 8414 Part 2, the difference between them and the reason why it was used.
Yeah. So once they've got a project which involves looking at the B4 requirement, you would expect them to read the relevant parts of approved document B, yes. See that there's an 8414 test, yes. And then investigate what an 8414 test is, at least in broad terms.
In broad terms, yes.
Yeah. Which would have told you that it was a system test, wouldn't it?
Yes, it would.
Now, training and CPD, just to ask you some more specific questions about that in the context of what we know about the Grenfell project. If we can look at paragraph 31 of your report on page 9. You say there, I've not seen sufficient evidence that the relevant individuals within the building control body were up to date with their CPD. Do you see that there?
Sorry, what?
Sorry, paragraph 31. I apologise. Can you see that
yes,
there?
At the time, yes.
Yeah, so when you wrote this, you said you'd not seen sufficient evidence that the individuals were up to date with their CPD. Mm-hmm. Yes?
Correct.
Now, you've now heard the evidence of both Mr. Hoban and Mr. Allen about the training and CPD activities that they personally undertook.
Yes.
And the training provided in-house by RBKC's Building Control Department. Do you have any comments to make on that, now you've heard that evidence?
I expected they would have done other than what was registered within RBKC, in as much as they had continued membership of their relevant professional bodies. I would just say that because you've done CPD, it doesn't mean to say it's 10 hours on fire, 10 hours on structures and 10 hours on something else. It's just an overall continuing professional development aspect. It wouldn't be specific to fire. But it would appear that the relevant CPD for their professional body was carried out.
Yeah, I understand. Now, we've heard that there was no specific training provided on the Part B4 of Schedule 1 of the Building Regulations and the guidance in approved document B on B4, save possibly for some training when the approved document first came out. and if there were any amendments. That's Mr. Hoburn's evidence. For the transcript, that's day 45, pages 17 and 20. What do you say about that? Would you have expected there to have been some training over and above just when approved documents change, relevant to the B4 requirement?
Not unless there was an in-house training program that was influenced by events or particular interest or changes in legislation or in the approved documents.
Right.
I'm afraid some authorities are better than others.
Yeah. We've also heard that there was no training provided on industry guidance, such as the BCA technical guidance notes. That's Mr. Hoban, day 45, page 21, lines 12 to 17. Again, what's your view about that there was no training provided on industry guidance? Is that to be expected, or would you have expected more?
I'm afraid, again, it would depend on the particular building control department and the structure within that department, whether they had somebody who could give in-house training or whether it could be bought in. But my experience would be that when the legislation changed, there would be some sort of document would go round, or there would be a group meeting to discuss and highlight aspects of change, etc. Or if there was if you had, let's say, a Building Control Alliance document that was particularly relevant to what was prevalent in the borough at the time,
Yeah.
then I would imagine that would have been
Yeah.
made known to all members.
I see. Now, in this inquiry, we're particularly focused on Part B of Schedule 1 of the Building Regulations and Approved Document B. A building control officer obviously has to deal with the whole range of issues covered by the building regulations and the approved documents. Is it reasonable, in your view, to expect a local authority building control department to provide training to their surveyors on specific aspects of the building regulations or the approved documents in those circumstances?
Yes, because I would expect the management to establish the weaknesses in knowledge and the specialisms. Particularly if you say, for instance, you had a structural engineer who was a qualified structural engineer, it may be that you would ask them to deal with the structural aspect of another person's patch area that they dealt with because they were more competent to deal with it. But a manager should be overseeing the staff to know where their failings or their shortfallings were, and then instigate training if it was possible to attain it within that organisation or outside.
Yeah. Is it reasonable to expect a building control officer to be a specialist in all 14 parts of Schedule 1 to the building regulations and associated guidance?
No.
What about the other documents such as British standards and industry guidance referred to in the approved documents? How aware would you expect them to be of those?
I would expect them to be aware of them. I would expect people to have a general knowledge of the documents they need to carry out the function they were performing, and then to be able to access that document and use it as necessary, and to delve into it to the depth necessary. And if they were becoming confused or didn't understand, or for whatever reason, to go up the management line to obtain that support to conduct that function.
Yeah. Now, just a final point on training, and I want to go to one of your conclusions. If we look at page 136, paragraph 445 of your report, we can see you're dealing with cavity barriers at this point, 445 at the bottom of that page. And you say this: in terms of the installation of cavity barriers on site, I have noted above that John Hoban states he was not trained to check this. I am surprised by this statement, as in my opinion it's part of the role of a building control body to check whether the installation of cavity barriers on site complied with the manufacturer's guidance. Do you see that there?
Yes.
Now, Mr. Hoban's oral evidence was that what he actually meant was that he was not trained to check on the tested and specified method of installation of cladding systems, but that he had picked up through reading documents how cavity barriers were supposed to be installed. For the transcript, that's day 46, page 126, lines 20 to page 128, line 11. However, he did also confirm that he did not have formal training on how to check cavity barriers on site. That was day 46, page 127, lines 17 to 22. Would you expect a building control officer to have formal training on how to check cavity barriers on site?
In my experience, the training would have been going out with somebody who knew how they should be installed and to be shown what they should be looking for. Or somebody going back, getting the information from the manufacturer as to how the tested cavity barrier should be installed,
Yeah.
and to make sure that that particular barrier was fitted in the required way for that particular barrier.
Yeah. So I think you're saying two things there, that you would have expected there to have been some training in the form of at least going out with someone who knew how they should be installed and showing them what to do. But then I think you're saying separately that they should know that they should be getting the information from the manufacturer of the cavity barrier and checking that carefully to make sure it was installed in accordance with the manufacturer's instructions. Is that correct?
Yes.
Yeah. Now, we've now heard the oral evidence about the training and experience that the building control officers had. Can I ask you, what do you think about whether John Allen was an experienced and competent building control surveyor with the necessary qualifications and experience to be a building control manager at RBKC?
Well, I wonder whether that's not something for the panel to decide. I mean, of course, Ms. Menzies can tell us what qualities were required for someone in John Allen's position.
I understand.
You think?
I'm happy not to put the question, but
Well,
it's one I've been asked to put. So
You can ask Ms. Menzies. Perhaps it would help us all if you were just to give us a resume of what you think someone in charge of a building control department, what qualities a person in charge of the building control department should have.
They should have experience in the building control industry, if you want to put it like that, generally know about building, have professional qualifications, also be a good manager, and make sure that their department was doing what was required by law for them to do, and that they were following what they'd laid down as being the right processes. But in doing that, they have to put those processes in a manner which the staff can access, retrieve, and learn from. And there also need to be checks and guards in their systems to make sure that the function was being carried out correctly. I suppose it also takes a certain personable nature to deal with staff, public, etc.
And what about on the training front? Do you want to say anything about?
Well, they should ensure that training is being undertaken as and when necessary. That's knowing the gaps in ability of their various staff and to keep up with the industry. Now, it might be turning around and saying, what have you done for your CPD, for your RICS or your structural engineering qualification, just to make sure people are on top. All departments, in my experience, do an appraisal. What the outcome of that appraisal is doesn't always come to fruition, shall we say.
Yeah.
Right, now do follow any of that up, or anything else that might bear on.
I'm going to ask you a related question, which is now take a building control officer, so not the manager of the department. Can you answer the same question? What skills, experience, training would you have expected a building control officer to have had, such as Mr. Hoban at the time?
Competency comes generally with experience, not necessarily with qualification, academic qualification. The competency would be competency to do the job for the projects they were given. You'd find people are very, very good at doing houses. You find people are very, very good at doing commercial projects. If they don't have, we'll call it a patch in their area, if they don't have the experience to gain from the different types of building, how can I put it? They often specialise in certain buildings, but overall, a competent building control officer should have basic structural knowledge, but in all of these, they need to acknowledge their limitations.
Yeah.
So, basic structure, definitely a basic means of escape and fire brigade access, and linings, because that's not particularly complicated. And then basic knowledge of drainage and that type of thing. But in terms of fire, it would be definitely means of escape and fire brigade access, because they are the basics of fire safety, shall we say. If you get into large complex buildings, then B3 and B4 become important. If you're dealing with residential, you would need a knowledge of B3, which is compartmentation, because that's the basis of the means of escape. To be a competent building control officer, you need a knowledge of Part B to the effect that every part of it is linked to them all. You cannot deal with one without considering the other.
Yeah.
But the priority, I would say, would be means of escape and B5, brigade access.
Yeah, that's helpful. Can I perhaps approach this question in a slightly different way? In general terms, having looked at their training and qualifications, would you say that their experience and qualifications and training are representative of those working in local authority building control departments at the time? So take Mr. Hoban, was his training experience representative of what you would expect to see in building control departments at that time, or your knowledge of that?
I would say yes, but adding that I find it strange of the reliance on the consultant, in-house consultant, for all matters relating to B1, to the means of escape.
I think what you're talking about is that you find it strange that within that team they were so reliant on Mr. Paul Hanson in relation to B1 means of escape matters. Is that what you're saying?
Yes.
Yeah. We're going to come back to how they used Mr. Hanson's role a little bit later. Mr. Chairman, I'm now going to turn to...
Right, can I follow up then with a couple of
Yes.
further questions? Mr. Hoban described how each of the surveyors was given a patch to look after, which would no doubt give rise to a lot of different sorts of buildings. Is that a common way of working as far as you know?
In local authority, yes. Yes.
And he also told us, or gave us a fair idea of the number of different projects that he was juggling at any one time. Now, some of them would require immediate action, some wouldn't. I think he said at one stage he might have had as many as 130 projects on the books, so to speak. Did that strike you as unusual or not?
Not really, on the basis, as you said, some could be dormant. Some could be a matter that would take, one visit and that would be it. Others would be in progress. I think for that number, you'd need to be well organised, have very good means of tracking what you were doing, and a very good diary system where, however you chose to do that, to control that number. And your manager should be monitoring how you were dealing with that number.
Yeah, thank you. Do you want to follow that up at all, Ms.
No, I've got some questions on that coming later. But
I'm sorry,
no, it's
I've
fine.
got ahead of you.
No, it's good. It's good. It shows we're on the right track. No, I'll leave those for now. I was going to say that I'm now going to get to Ms. Menzies' criticisms of what happened on Grenfell, so it's a good time to stop.
Well, this is a good time to have a break then, isn't it?
Yes.
Yes. good time to have a break for lunch then, Miss
Okay,
Menzies. So we'll stop now. We'll come back and resume at 2 o'clock. And as before, please don't talk to anyone about your evidence over the break.
Thank you.
All right, thank you very much. Thank you. 2 o'clock then, please.